Good morning, everyone, and good evening to some of you in other parts of the world. My name is Evan Laxmana. I'm a senior research fellow at the Center on Asia and Globalisation. Let me first welcome you to our second episode of Counterpoint Southeast Asia, our new initiative here at CAG, where we bring in the top emerging scholars and analysts from Southeast Asia to discuss major questions facing the region. Our first episode, in terms of both the YouTube video as well as the publications, are all online now, and you can check them out in our website. For this second episode of Counterpoint Southeast Asia, we'll be tackling on one of the major questions facing the region over the past 2 decades regarding the Code of Conduct in the South China Sea between ASEAN and China. For the past 2 decades, since the 2002 Declaration on the Code of Conduct, both ASEAN and China has engaged in a slow but steady negotiations in terms of how to create a legally binding final Code of Conduct that's supposed to be the primary tension management mechanism between ASEAN and China, but more specifically between the Southeast Asian claimants and China. Now, for the last few years, there's been significant progress after maybe about 15 years of slow rolling. We finally agreed on a single draft negotiating text. There's been some sort of arbitrary timeline set back in 2018 that we can finish this in 3 years. That certainly hasn't happened. And there's been more debate about the nature of the COC itself. Should it be binding? Should we focus on passing a low quality COC, but we can pass one? Or should we aim for a higher quality COC that not only is legally binding, but also mentions the specific geographic scope of the COC? What is the end game of the COC? If it's designed to be a tension management mechanism and not a dispute resolution, what is necessary for us to take that dispute resolution step forward? And more importantly, and I think this is at the heart of our debate today, now that we're still at a position where we're not clear about the key benefits and values of the COC, because for the past 2 decades, if it's meant to be a tension management mechanism and then sort of freezing the developments on the ground, that certainly hasn't happened as we've seen in recent years. So some would argue that the tension management aspect of the COC has actually failed. And it's not really clear whether the current single draft negotiating text will fix those problems. So should ASEAN walk away from the current COC process? That's the heart of the question for our second debate. And we are very glad this morning to be hosting Bich Tran, who's joining us from Washington today, Aristio, who's joining us from Jakarta today, and Colin, who's joining us from Singapore. So in case you haven't been to our debate sessions, this debate will largely be a conversational style. There won't be any formal presentations. We'll be opening up the floor for Q&A right immediately. So if you have questions, even before you hear them speak, feel free to post them in our question box, and we'll get into your questions as soon as possible. But for the first question, let me start with Bich. Bich, you argue in your essay that ASEAN should indeed walk away from the COC process because it has been neither productive nor will it be particularly feasible. Instead, Southeast Asian claimants in particular should pursue judicial procedures and seek binding decisions, whether it's through the ICJ or through the International Tribunal for the Law of the Sea. Could you elaborate on your argument? And if these options are available, why haven't Southeast Asian claimants, outside of the Philippines at least, pursued them? More importantly, would you go so far as to say that the COC process has to some extent indirectly facilitated the deterioration of UNCLOS itself, and therefore abandoning the COC process and pursue the UNCLOS sanction option could actually strengthen UNCLOS? So if you could elaborate on these questions and your arguments in the essay further, that'll be great. You have 10-15 minutes, Bich. Thank you.
Thanks, Ivan, for the question. So yes, it has been more than 25 years since the idea of a code of conduct were first endorsed by Indonesia in 1996. But until now, we have not had any concrete agreement. So in my opinion, the negotiation has not been productive. And back in 2002, China agreed to the declaration on the code of conduct of parties in the South China Sea, just to convince its neighbors about its peaceful rights narrative. But since then it has stonewalled the process. And another reason why the COC process has been so slow, because ASEAN countries, are too divided. Among 10 members, only 4 of them, Brunei, Malaysia, the Philippines, and Vietnam, are the South China Sea claimants. Other non-claimants members have little to no interest in standing up against China, while they have various different reasons to accommodate Beijing's stance. And you also, my argument is that also the protracted process has given China to the time to change the facts on the ground in its favor. So China has consolidated its administrations over the disputed waters. For example, in 2009, it set up a hamlet administration on Woody Islands and Tree Islands in the Paracels. And furthermore, is in 2012, it established the Sunshine City to oversee, vast areas of the South China Sea, including the Paracel, the Spratly, Macrosphere Bank, and Scarborough Shore. And with it went even further by forming 2 new districts within the Shanxia city to expand its control. Besides that, China has, also conducted a large-scale reclamation projects to turn rock and reef into artificial islands and militarism. So all of those activities, has enhanced China's long-term presence in the South China Sea significantly. And my second argument is that the COC process is not viable. So South China, South Asian countries, wants to have to conclude a code of conduct because they believe that it will constrain China's behavior. However, China has no reason to tie its own hand. So, and instead, China wants to use the code of conduct to exclude external parties, like external companies from oil and gas development in the South China Sea, and also like put restriction on joint military exercise with other powers, including the United States. So if the COC is on China's term, I think it may not be in ASEAN's interest to conclude a binding agreement. And if the agreement is the agreement is not binding, then there is no guarantee that China will uphold the agreement. And from the experience, we know that even though China already adopted the DOC, and it also signed an agreement on the basic principles, in guiding the settlement of maritime issues with Vietnam, China has, repeatedly interfered with other claimants' economic activities in their own exclusive economic zones. And China also intruded into Vietnam's water on multiple occasions. So on that, with their binding agreement, then we cannot trust China will uphold those. And I mentioned in my essays that parties of the United Nations Convention on the Law of the Seas are free to choose one of the following means to settle disputes, in relating to the interpretation or the application of the convention. So one is the International Court of Justice. The second is the International Tribunal for the Law of the Sea, established under the Annex 6 of UNCLOS. And number 3 is an arbitral tribunal constituted under the Annex 7, or a special arbitral tribunal constituted under the Annex 8 of UNCLOS. However, after ratifying the treaty, China made a declaration that it would not accept any of the compulsory procedures mentioned above with respect to dispute that relating to sea boundary delimitations or historic bays or towers, or concerning military activities, or in respect of which the United Nations Security Council is exercising the function assigned to it by the UN Charter. So there's some challenge there. However, now Southeast Asian claimants still may, submit any dispute falling within, like outside of those categories mentioned by China to the procedure specified in UNCLOS. To give an example, you all know about the 2013 case that the Philippines institutes an arbitral processing against China. So it was under Annex 7 of UNCLOS. And the arbitration concerned the role of historic rights, the source of maritime entitlements, the status of specific maritime features, and the lawfulness of certain actions by China in the South China Sea. So those areas didn't fall within the 3 categories that China made the reservation against UNCLOS. So that's why the arbitral tribunal, had the jurisdiction to rule over the case. And Vietnam, even though Vietnam was not a party of the case, but in 2014, the Vietnamese government submitted a paper, it's a position paper on the matter of the jurisdiction on the case, and it said that Vietnam has no doubt that the tribunal has jurisdiction over the proceedings, and Vietnam also took that chance to repeat its stance in the South China Sea. I think that even though Vietnam welcomed the rulings in 2016, but it has reluctant to fight its own case. I think mostly because of the concern that about the economic dimensions. So in Vietnam, China has been Vietnam's biggest trading partner since 2004. So Vietnam would like to maintain a positive economic relations with China as many other nations. But in its official statements, Vietnam never ruled out the option to use legal processes. Even though China's reservation to UNCLOS made it difficult to address the issue of boundary delimitation through the judicial procedures. However, Southeast Asian countries could still fight like similar cases to the one of the Philippines under Annex 7. to determine the unlawfulness of China's interference with their oil and gas activities in their exclusive economic zones. Not just Vietnam, but also Indonesia and Malaysia. You have heard a lot of news about China's harassment in their own ECZ. They could also file some case under Annex 7 to rule about China's unilateral fishing ban in the South China Sea. So I think that even though China might choose to ignore the rulings as it does with the 2016 award, but it could face criticism and pressure from the international communities. So I think, for example, if the Philippines later decides to bring the 2016 ruling to the United Nations and put pressure on China to follow the ruling, then Vietnam, Indonesia, and Malaysia may see the merit of doing the same process. And the Philippines already has a very comprehensive case, cover a lot of areas, but Vietnam could still add something new to it by bringing the Paracel Islands into the case, or Malaysia or Indonesia can file a case against China's harassment in their with their oil and gas activities. And if there are a lot of well documentation of China's harassment, they may win the case easily. So to even second question, I don't say that the COC process contribute to the deterioration of UNCLOS, but I think that ASEAN should walk away because it has been neither productive or feasible. So I just think that instead of wasting their time and energy, they could direct those resources into doing something that could produce some more concrete result. I will stop here. Thank you.
Thank you so much, Bich. That was a very clear and articulate argument, and I particularly enjoyed the fact that you make a very clear position that we should walk away from COC, if for no other reason that it hasn't been particularly productive, and nor has it been particularly feasible, and we should instead spend resources and time and energy, which we don't have a lot of, on actual options to move the delimitation process at least a bit forward. Let me go to Aristio, which I think presents a different opinion, if not the complete contrast to Bich's argument. In your essay, Aristio, you argue that the COC should be kept because it is the only mechanism or option to ensure China's compliance with a rules-based order. China was actually part of the negotiations that led to UNCLOS, which it has also ratified. How exactly will the COC ensure China's compliance when it already pick and choose which part of UNCLOS it wants to follow? Surely the COC will not supersede UNCLOS. So why should we assume that China will act in good faith and comply with the less legally binding COC just because it helped negotiate it? I think these are contrasting key arguments to your position and Bich's position. Could you elaborate on your arguments, Aristio?
All right, thank you. Thank you very much. First of all, I think I would like to thank Mas Evan also for the Center for Asia and Globalizations for organizing this very timely and important webinar, I think, on the South China Sea Code of Conduct. So let me elaborate a little bit about my articles or my essays on why should ASEAN should not walk away from the South China Sea Code of Conduct negotiations. First of all, I think as Bich already elaborate in her presentations that we've seen a lot of Chinese attitudes towards international law, specifically in the South China Sea and towards the 2016 tribunal's ruling. And what we saw that is China is kind of like deviate and uncomplied with the tribunal's decisions and also with the general rules and norms of the United Nations Conventions on the Law of the Sea. So I don't think that if there will be another international judicial mechanisms, for example, if other ASEAN countries brought a case to the International Court of Justice or to the International Tribunals on the Law of the Sea or other international judicial mechanisms, that China will comply, partly also because of China's made declarations that they won't comply or they won't using an international tribunals mechanisms for maritime delimitations or other stuff. So I think it's less likely that if there isn't other tribunals rulings on the South China Sea, China will comply or will follow up the international procedure. So I think it's less likely that China will that an international tribunals will change Chinese behavior in the South China Sea. And then the second thing is that, of course, what happened in the South China Sea is a very complex problem. It's beyond an ordinary maritime boundaries delimitations. It's involved a very complex situations that is involved the economic interest, the political interest, and also the major power rivalry here in the region. So I think the problem is very much complex, which I think, and I tend to agree with what Ambassador Hafaz Ugroseno said, that we won't likely to see that these South China Sea disputes being resolved in our generations. So there should be another mechanisms that to ensure, or at least to make sure that the disputed will not be escalated, or at least there won't be an open war in the South China Sea. And I would argue that the mechanisms, at least that haven't been tried yet or still can be maximized, is by using the South China Sea Code of Conduct. Why I argue that way? Because I think in many occasions, in many bilaterals meeting between ASEAN foreign ministers and Chinese foreign ministers, both parties always underline that the importance of having a code of conduct in the South China Sea. All ASEAN states, of course, have the interest in having a code of conduct to maintain peace and security in the South China Sea, to at least put pressure and behavior of China Sea not to provoke or to have a limitations about law enforcement in the South China Sea. But on the other hand, China also have interest in having the code of conduct. Partly is because of China wants to keep the disputed only between ASEAN and China, and to avoid major powers present and roles in the disputed area. So China is, I think, has their interest in having the code of conduct. So the opportunities now is how to maximize and capitalize the Chinese interest in having a very good and solid code of conduct that regulates, that can prevent any provocations and also a further dispute escalations in the regions. So that's why mainly why I argue that the code of conduct might have a chance in keeping peaceful and security, which is, I think, the last thing that we want to put in the South China Sea. But of course, it's not like it's not a zero-sum game, or it's not like we should have the code of conduct in all kind of circumstances. Of course, in my articles, I also argue that there is a limitations, of course, that the code of conduct should comply with the norms and rules of international law. ASEAN states should not conclude a code of conduct that actually legalize something that is illegal under international law. So therefore, I think it's necessary for ASEAN to make jointly to ensure that ASEAN will have a code of conduct that is comply with the role of international law. I think I also agreed with Bich to some extent that we see that the diverging positions between ASEAN states in regard to the South China Sea. Of course, it's not all ASEAN is a claimant in the South China Sea, but also we see that actually we see two diverging positions, so to speak. There's a land-based ASEAN and there's a maritime-based ASEAN, which have more interest in the South China Sea. And ASEAN have also a different degrees of relationships with China. Some countries, maybe Laos, Cambodia, they have a very close relationship economically with China, as well as other ASEAN maritime states. So I think it's with that kind of close relationships, it's going to be hard to really file a case to an international tribunals. And therefore, the best mechanisms, I think, it's to negotiate something that is both parties intentionally to want that mechanisms to happen. So even though that ASEAN might have a different positions towards the dispute in the South China Sea, but I think all ASEAN states have a common positions in order to maintain peace and security in the disputed area. And the code of conduct might will regulated certain kind of norms of what can be done and what should not be done in terms of law enforcement, and also to address other issues, for example, such marine environmental issues or fisheries issues. But the thing is that code of conduct, it's very much important, and that's why ASEAN should still keep in hand in order to secure that the code of conduct is comply with international law. I would also argue in my articles that the necessity of ASEAN to ensure that the code of conduct is there is, I think it is very much important. First, because I think that the South China Sea issues, of course, as Evan mentioned earlier, is the most pressing security issues here in the regions. And ASEAN, as a regional organizations, I think it's important to not walk away in such a pressing security issues, and therefore ASEAN should at least open up the discussions and negotiate a code of conduct that is complied for both countries. And the next question is, how can we ensure that China will comply to the code of conduct if the code of conduct later on will not be legally binding or as legally binding as the UNCLOS? So I think there's several reasons. First, I think, as I mentioned earlier, China have interest in having the code of conduct in order to keep the relationships. And that I think that is the a very important modality for a state to comply with international law, is that will it serve their national interest? Of course, I think China is now become a rising superpower, and all superpower in the histories, I think, is always pick and choose the rule of international law that serve the kind of interest. So China, and with if the China have the first interest in the having the code of conduct there, I think it's will more likely that China will comply to the code of conduct later on. And then the second thing is that we can, or ASEAN can assure during the negotiations that there will be an internally driven mechanisms to assure compliance. For example, there's some research by the Center for Humanitarian Dialogue in order of important for the code of conduct to have at least two main issues. The first one is the compliance and monitoring mechanism. So there should be a monitoring and compliance mechanism within the code of conduct. For example, in creating a bodies that represent from all of the code of conduct parties, an independent body to then assure or decide whether or not there is a violations of code of conduct. And the second thing is the dispute settlement mechanisms. Of course, that what we've seen in the previous 2060 tribunals is not a failure, but China won't comply and won't respect to the ruling. So I think the degree of dispute settlement mechanisms, it's also should be considered. For example, there should be like a reconciliations or more like in a communications that will make China trust the process. So I think that's my main argument. But also in the last part of my articles, I argue that it's not a must to have a code of conduct in all conditions. In the last few years during the negotiations, I think one of the toughest issues is about the scope, for example. So whether or not it should be applied in the whole 9-dash line or so. But the most important thing that ASEAN has to assure is that the code of conduct should comply with international law. If later on then China will pressing that the China should agree upon something that is illegal under international law, then I would argue that it's better not to have the code of conduct rather than we have a code of conduct that legalize something that is legal under international law. So I would argue that it's still important for ASEAN to keep its hand and assure that the South China Sea Code of Conduct will be concluded between ASEAN and China. I think I'm stopped there.
Thank you, Aristeo. I thought that was a very clear argument as well, saying that essentially you're not saying we should keep it at all costs. You're saying that we should keep it based on certain conditions. So it's more of a conditional acceptance, if you will, about the process itself. Now, let me turn to Colin now, because I think this relates to one of the key points that Aristeo mentioned as well about the utility of the COC for confidence building. Colin, you argue in your essay that despite the many failings of the COC, as a non-claimant, Singapore would still support the process because at the most basic, it would serve as a form of confidence building mechanism to help ameliorate tensions that erupt from time to time in the SES. But the very fact that tensions have erupted at the SES over the last 2 decades, doesn't this challenge that confidence building purpose? The mere presence of the COC process hasn't really stopped the tensions, nor has it stopped China from changing the facts on the ground, and therefore might even prejudge the future maritime delimitation talks. Could you elaborate on your argument why it still serves as a confidence building measure?
Great. Thanks, Evan. Thanks so much. Yeah, this is a very interesting debate, and of course, I really want to thank you and your colleagues over at the LKY School for inviting me for discussion. And having listened to what Bich and Aristeo has said, my argument tends to fall or align more closely with what Aristeo had proposed, and to say that we shouldn't walk away from the process itself. I think more importantly is to ask the question whether ASEAN will want to walk away from the process. And the fact that if, let's say, there are people within ASEAN who wanted to walk away from the process, then will there be a consensus for ASEAN to walk away from the process? And will that in itself lead to a whole new set of disputes within ASEAN itself that will exacerbate the problem in the process? So I think there are some reputational costs that ASEAN has to bear with. And I mean, it's not to say that ASEAN has not already having to bear with quite a bit of reputational costs over the South China Sea over the years. I mean, if you look at what happened with the DOC and now what happened with the COC, I think more of the hope is, being put on the COC and to, pray that it will really succeed. Now, I just want to highlight a few points before I go right into your question proper, Evan. I think firstly is that, in my thought is whether the code itself is going to be binding or not, or legally or otherwise, is not as important. I mean, it is a moot point if we don't have a good COC in the first place. And a good COC, in my mind, is something that is prescriptive. It clearly spells out the do's and don'ts for each signatory so that it is clear under which circumstance there will be violation, and we have a proper set of mechanism to determine that. So what I'm referring to will be what most arms control theories will tend to talk about will be the issue of compliance, verification, and enforcement. Without a CVE mechanism inbuilt into the COC, we are basically left with nothing more than just a DOC plus. I think this is important. Without this sort of mechanism, then it is perhaps not that wise to talk about whether it's binding or not binding legally or otherwise, because by talking about that, we are prejudging for the COC, and thereby we are setting a sort of expectation too high that is somewhat unrealistic in practice to accomplish. So this is what I will highlight right at the beginning. But again, to stress that I would not support walking away from the code itself because of, as I mentioned earlier, the reputational cost that ASEAN may have to bear. Whether China will want it or not is, of course, quite another matter altogether. But I think most people will agree that with the absence of a proper code, at least the continued dialogue process is much better than not having engaged in one. And the fact that these countries come together and they're willing to talk about it does highlight some form of optimism. There's some hope for us to have. So I think this is one aspect that I want to really highlight. And of course, I wouldn't say that the process itself is a guarantee there will be no tensions. In fact, one would try to even see whether there will actually be tensions or any violations after the COC is being promulgated. And the hope is that we will have a code that is able to forestall this sort of contingencies from taking place. But I think at this point, I believe I might have already, highlighted or addressed some of your pertinent questions, and I look forward to the discussions later.
Thank you so much, Colin. Let me get to the Q&A session now. We've had a couple of questions already. The first question goes to Bich. This is from Tokpam. How to make a meaningful COC as the status quo in the South China Sea? Has it changed much? China has quickly reclaimed and militarized some of the features. So I guess the question is to Bich, is to what extent a meaningful COC kind of freezes the status quo, or can it sort of overturn the current status quo that's actually not good for the Southeast Asian claimants? Bich.
Yeah, thanks, Tukpa, for the question. Basically, in my remarks earlier, I also touched upon this, that the protracted process of COC negotiation, has given time for China to change fact on the ground. So do you also agree that the status quo in the South China Sea has changed a lot? So I don't think that. That's why I said that ASEAN should walk away from the COC process and invest time and efforts to do some pursue some other options that have like more concrete result.
Thank you, Bich. Aristeo, this question is for you also from Tokpam. China has agreed with ASEAN to make a binding COC in line with international law. What do you think are the meanings of binding and in line with international law in Chinese perspective? Are they different from how ASEAN views it? And how do we synchronize or harmonize those different interpretations between ASEAN and China about the meaning of binding and in line with international law? Aristeo.
Right, thank you very much, Tukwan, for the very important questions. So I think let me address first the term of binding or legally binding on international law. I think it's in international law there might be a different interpretations of what considered as binding. For example, in some treaties, binding means that contracting parties have create their own domestic legal mechanisms for implementations, or if it's concluded as a treaties, then there should be a domestic process of ratifications process. But here, what binding here, what important of binding here is, of course, the intention of parties that the documents, the treaties or MOUs or anything that they signed is that the country is particularly bound fully to the documents. And as a consequences, if all parties agree that it is a legally binding principles. For example, if one country is accused that other parties it's not compliant with the rules and regulations or with the treaties or with the documents, they can brought to the international dispute mechanisms, for example, to the International Court of Justice or ITLOS, and that is agreed upon. So that is the meaning with binding, what I understand here for the South China Sea Code of Conduct. So for example, if then there is like an illegal maneuver or there's an act of provocations that is breach the code of conduct, then other parties can bring it to international tribunals based on that code of conduct. And the second is, it's important, of course, to make sure that the code of conduct in line with international law. And what does that mean? So I think it can also means a lot. But let me give you examples on the most important issues. I think what considered as in line with international law is, of course, when I talk and elaborate in my articles about the scope of the code of conduct, where the code of conduct will apply. Will it only be applied in the overlapping maritime area that is legal under international law? For example, coastal states might claim maximum 200 nautical miles of exclusive economic zone. And if the 200 nautical miles, there's an overlaps So it will only be applied in that overlapping legal 200 nautical mile maximum claim that is legal under the United Nations Convention on the Law of the Sea. So what is not illegal is that if the code of conduct later on will all be applied in the whole 9-line claims because of two things. The first, I think it's no such thing as 9-line under the international law, under the United Nations Conventions on the Law of the Sea. And second thing is because of the tribunals 2016 has declared that the 9-line is illegal or doesn't have a legal basis under international law. So if later on the code of conduct will be applied in the whole 9-line, it has already been illegal under international law. So that means that it's agreed upon something that is illegal under international law. Because then, if from Indonesian perspective, if later on if it will be applied in the whole 9-line, so that means that Indonesia will have then a dispute with China, because right now Indonesia's position is that we're not recognizing the 9-line because it's illegal under international law, and our position says still stick to international law. So if then the code of conduct recognize the existence of the 9-line, that means that Indonesia will recognize the existence of the 9-line. Then we have a dispute. So I think those kind of things, it's important. I think that is the bottom line for ASEAN to whether should agree or not agree with the code of conduct. So I think that's going to be my answer to Bich's PAM questions.
Thank you, Aristeo. Colin, this one is to you. Lastly, also from Tukpam, how can the COC prevent and manage incidents in the South China Sea? And how to consolidate the content of prevention and management of incidents into the single draft negotiating text? Colin?
Thank you, Evan, and thank you so much, Tukpam, for the question. It's a very salient question. It goes back into what I mentioned earlier about having a prescriptive set of mechanism, and overarching it, will be having a CVE set of provisions to govern that. So I think the first important thing is to highlight, what are we trying to prevent in the first place? And this goes down into the very heart of the debate, or one of the debate issues is how do we define the term militarization, right? I think this is something that I believe, not just within ASEAN or with China, even amongst the other members of the international community who have, clear stakes in the South China Sea, that there is so far no consensus on what amounts to militarization. And basically, any activity could be deemed as provocative. So what is important is that if there is no consensus on militarization, then at the very least, ASEAN and the other parties, I mean China in particular, will have to come down with an entire list of activities that are considered as violations of the code itself, or being seen as prejudicial to peace and stability in the South China Sea, and thereby from that origin is thereby easier and possible to come up with a set of confidence building measures. And of course, touching on what Aristeo had mentioned is also about scoping. It's important to underline where we apply the code in which geographical area. Without a consensus on the scoping or geographical scoping of the code itself, it is thereby another set of ambiguity that is open for violation, with the potential of it getting away scot-free as such. So the other thing that I will highlight here is that it is not to say that by all means, by the time that the code is being promulgated, it has to be a perfect code. Just like in the spirit of the current single draft negotiating text, where it is called a living document, what I'll propose is something similar to that or equivalent to that, is to have a clear set of provisions that allow for all 11 members to review the code on a regular basis, and or as and when required or expedient to do so, in order to continue to evolve and improve the code itself along the way. So we don't stay static, and thereby we can allow the code to be flexible enough to actually handle other potential problems going down the line. So I hope that addresses the question. Thank you so much.
Thank you, Colin. Next question, I think, is for all three of you. This is from Fred Kleem. Has China already achieved its main strategic objective in the South China Sea? And if so, would at this stage, COC is not simply codifying an existing status quo that is already well out of the scope of legality? Let me start with Bich. Bich?
Yeah, so I think one of China's objective is to consolidate its control over the disputed areas. Then I think in that respect, with the reclamation, militarization, and also the administration units, then I think China has, to some extent, achieved its objective. So. So I think that, to your question, I think it's quite very relevant there that, so I think, my argument is that ASEAN should walk away from the code of conduct process because of the exact argument. So if you, want to talk like how the code of conduct can be, better apply in that situation, then I would give the floor to Aristio and Colin to answer that question.
Thank you. Aristio?
All right, I think whether or not China has already achieved their main objective in the South China Sea, well, I'm not very sure about that, because I think the main objective of China in the South China Sea is also to control all of the bodies, waters, and islands in the South China Sea, which I don't think that it's achieved now. And I think what China trying to do is that with the constant practice, China wants to legalize, I think, and China positions, I think, in the code of conduct is, I think that China want to make that positions, that assertions, that claims, it's being recognized with the code of conduct. So that's why I think, again, that the scope is very important, and also the provisions, I think, later on within the code of conduct, it's very important. And I think we have to make sure that that the code of conduct will not only be the means of China in order to legalize their claims. So I think the Chinese strategy now, with the gray zone strategy, the ambiguity strategy of China in the South China Sea, it's something that China's do in order to maintain their objectives in controlling. So what should the code of conduct do? I think it should make it clear. It should avoid the gray zone tactic. It should avoid the not clear legal and non-legal aspect. So I think that it's going to be the my answer on the questions.
Thank you. Colin?
Thanks, Evan, and thanks, Fred, for the question. And building on what Bich and Aristio had mentioned, I will propose roughly 3 to 4 postulated main objectives that China may want to achieve in the South China Sea. And we sort of run through that briefly and see whether we can tick the boxes for Beijing. One is, for the ASEAN countries or for the international community to forget that there is a 2016 arbitral award, and thereby to pretend that it never exists. But that we can't tick the box, because simply we have ASEAN countries, the claimant states in particular, and the international community in particular, from time to time highlighting and reminding the rest of the world that there is such an award, and thereby China needs to adhere to the award in particular. And that even applies to the Philippines under Duterte, which is supposedly friendly to China. So that's the one objective that hasn't yet been achieved. Second, in terms of the physical control, at least compared to, say, 10, 20 years ago, China has consolidated its physical control and being able to project force in the South China Sea. That particular box has been ticked somewhat, right? The third one is that, in the absence of any other agreement, China will expect the other claimants not to undertake certain types of provocative activities, including unilateral energy exploration program with or without external partners. That box hasn't been ticked at all, and it will not, because of the fact that the other ASEAN claimant states are more than interested to continue with what they are doing on their own with their domestic energy companies or with external energy companies. They are not going to compromise on that. Finally, is to think about whether China is thinking about, blocking the extra regional presence in the region. That is one of the objectives, and that goes back to China's, frequently talked about, preventing other extra regional powers from meddling in the South China Sea program. And I think this is something that relates to what was one of the suggestions made by China, which is to give it some sort of a de facto control over whether the other regional countries could engage in joint military exercises. That box definitely hasn't been ticked. As we can see, other ASEAN countries are still exercising with other extra regional powers, and there is what I know to be a pushback against such a proposal. So I don't think the objectives have been achieved in the South China Sea. And I agree with what Bich and Arisha has mentioned. At the very least, with a code, we're able to tie down on the do's and don'ts, and thereby from there, it is better to judge what China will do subsequently. Thanks so much.
Thank you, Colin. The next question I think is also good for all three of you. This one is from Romain Kylo. What role, if any, do you assess powers such as the US, Japan, the EU, or India can play in helping to conclude and enforce an effective COC or some alternative mechanism? So this is basically a question about the role of external powers. Let me reverse the order and start with Colin again. Colin? You're still muted, Colin.
My apologies. I think this is a very important question and something that has come out in the more recent years in particular. I think importantly is to look at it from a few perspectives. I think one is that extra regional powers can help to facilitate the process itself by, from time to time, helping to remind the world the importance of international law, UNCLOS in particular. I think on that count, we have been seeing some of the extra regional powers doing that. For example, putting up statements or note verbal to the UN that stresses upon the 2016 arbitral award. I mean, in a way, the sad thing to see is that we don't see many ASEAN countries highlighting or reminding, everybody about the 2016 award. And, by and large, we also have to depend on extra regional powers to do this job for us. So I think on that count, it is very helpful. In particular, if we are looking at powerful states like US, Japan, India, or powerful institutions like the EU doing that, it adds weight to that particular point. Second is that to facilitate the COC is important to actually improve the resilience of the Southeast Asian parties in the South China Sea. And that will mean, building the maritime capacity of the South China Sea parties, whether you talk about the navies or the coast guards, or you're talking about, measures to ensure that the individual South China Sea littorals could clamp down on illegal fishing, and that in a way could help eventually allow some of the South China Sea parties in Southeast Asia to resolve their own bilateral disputes in that mix, and thereby helping to improve the leverage in the discussion with China on that count. So I thought that will pretty much sum up what I will respond. Thank you.
Thank you, Colin. Aristia?
All right, of course. Thank you very much. I think I also agree that this is a very important questions, and I agree with most of the Colin's answer on the questions. But I think if we see the roles of countries outside ASEAN, specifically major power countries such as the US, the UK, I think they should play a quite important role. But I think first of all, we have to address that the recent presence of the US and UK in the regions or other European Union, I think ASEAN countries have quite a different positions on that. Some countries will openly welcome, and some countries a bit cautious about those presence in the South China Sea, because it might or might not provoke China's assertions in the region. So I think that is the first about the really presence in the South China Sea. The second thing is I think I also agree with Colin that I think the one who can really solve this dispute or should maintain this peace and security in the dispute is, I think, only between China and the climate, Southeast Asia climate countries. And therefore, I think the role, rather than just to sending like a huge warships or like sending military in regions, I think it might have posed a risk of escalations. But I think with the role of more, for examples like capacity building, joint training, I think it's for between those either US, UK, or other European or major power with the Coast Guard here, Bakamla, or Navy here in the regions. So increasing the capacity of the Coast Guard and law enforcement agency here in the regions, I think it's will be much more appreciated rather than just like having a strong provocations. But also, I think I completely agree that with their presence and with giving a statements of complying with international law, I think it's good to have or to notice Beijing's that there are a lot of supporters for ASEAN and for the rule of international law, and there I think we'll put some sort of like a pressure to Beijing to comply, or at least not to provoke or doing something that is more provocative. So it's like give a cautious that they are here. And that's why Beijing should comply with the rules and norms of international law.
Thank you, Aristio. Vic?
Yes, thanks. So I agree with Colin about the point of keep mentioning DOD, DOC and COC in joint statements. So that's what the United States, Japan, and India has done a lot with Southeast Asian partners. Every time they sign a joint statement, they always mention those two. And even with the recent joint vision statement, which in the US and ASEAN summit just took place in Washington, D.C., they also promote to comply with the DOC and stress the importance of concluding a COC. And I also agree with Ari's stories about the concern of some Southeast Asian countries about the presence of external power in the South China Sea. And for example, you may say that Vietnam, for example, is strongly supports the freedom of navigation operation conducted by the United States to challenge China's claim in the South China Sea. But actually, some of those FONOPS operation also target Vietnam itself. And like other countries like Indonesia and Malaysia has raised concern about some initiative, for example, like AUKUS, like could raise tension in the South China Sea. But I think that come back to the joint statements between external powers and Southeast Asian partners to promote the DOC and the COC. I think it's important because it's clearly shows that the South China Sea is not just the issue of Southeast Asia and China, but it's getting a lot of international attentions.
Thank you, Vic. The next question goes specifically to Colin. This one is from Hunter Marston. Colin, Singapore has drawn Chinese anger in the past when it's seen to have spoken up on the South China Sea. Has Singapore adjusted its strategy? How can Singapore support freedom of navigation without attracting backlash that threatens its own relationship with Beijing or other powers like the United States? Colin?
Thank you, Evan, and thanks, Hunter, for the question. To briefly address that, I think firstly is there were some misperception earlier, ever since Singapore was one of the ASEAN member states to take note of the 2016 Arbitral Award, and there was a whole slew of tensions with China, including the rather unfriendly exchange between the Singapore ambassador to China and with Beijing. And then thereafter, coinciding with the detention of the armored vehicles in Hong Kong, and thereby after which there were some observations made by commentators that Singapore had sort of quietened down, and some even went further to say that Singapore has shifted its position in line with China. I don't think that is true. I don't think Singapore has changed any position at all. except that there are some adjustments that appear to have been made. Singapore may not want to openly talk about the 2016 Arbitral Award, but to refer to it implicitly. For example, the continued repeated emphasis on UNCLOS in the various official statements and remarks made by Singapore policymakers. So that is one area where Singapore could contribute in order to try to highlight, to amplify the message about rule of law in the South China Sea. And of course, that should logically refer back to the 2016 Arbitral Award. So that is one. Second is that without any discrimination and having a more consistent position on the South China Sea with regard to rule of law and freedom of navigation, it to support an inclusive arrangement in the region, including embracing friendly powers from engaging in freedom of navigation activities. Not to say that to engage in foreigners per se, but the fact that given the South China Sea is an international medium, to allow every party with stake in the South China Sea the means to contribute to security, I think is important in a way to emphasize freedom of navigation and overflight in that regard. Yeah, thank you, Evan.
Thanks, Colin. This question goes to Aristio. This one is from Henrik from RSIS. You mentioned in your presentation about the compliance and monitoring or proper mechanisms for ensuring compliance and monitoring as an important part of the COC. But if China does not want to be bound by such mechanisms, as it has shown, how do we then conclude a viable COC without such compliance and monitoring mechanism? Aristio?
So, okay, thank you very much for the questions. And I think it's very much important. What I mean by a monitoring and compliance mechanism is, I think if we go through a lot of treaties, each and every treaties have kind of different monitoring and compliance mechanisms. But one of the, I think, viable monitoring and compliance mechanisms from so many treaties that we looked at with the Center for Humanitarian Dialogue is that some treaties actually have created specific bodies, established specific bodies, consist of like experts, which is less political, appointed independently from all the parties to the treaties, and that particular body will receive all, for example, like informations or report or allegations about the incompliance with that treaty. So I think with those kind of mechanism, I think it's possible, because within that body that there will also be a Chinese representative. So that kind of bodies will then decide. It depends whether or not that to what extent that body can have said or can do something. But at least with those kind of like compliance mechanisms that involve China is something that is we think it's China will more likely to comply and observe the code of conduct. But the questions then, what about if China doesn't want to be comply with those kind of disputed compliance mechanisms? I think that that's also, of course, first I think it's very possible. Looking how China behaved with the 2016 tribunals, it's also possible that China will not comply. But if China will not comply with mechanisms that already been established, for example, so to speak, so I think it's also possible to make evaluations to the code of conduct later on. But for example, if China has already agreed, for example, to conclude such a compliance mechanisms, and then later on China not comply, I think that's possible that should be an evaluations of compliance, and it's also affected to what extent the COC, for example, can last. So I think, but first of all, with the mechanism of monitoring and compliance that is involved China representative, for example, I think will put China more on likely to at least internally driven comply with the code of conduct. But if not, later on China does not comply, I think there might be an evaluations or mechanism that it's set by the code of conduct for in compliance with the COC.
Thank you, Aristio. I think it's also worth interjecting a little bit here from my part. If ASEAN doesn't really have an enforcement mechanism for what happens when its charter provisions are breached, I think the issue of the South China Sea compliance is certainly something that should get ASEAN thinking a bit further on those issues. Let me go to Big now. Big, there's a question directly for you from Hendrik as well. If Southeast Asian claimants use the mechanisms as you suggested under international law, whether it's through the ICJ or the Tribunal on the Law of the Sea, like the Philippines did in 2016, and then China refuses to recognize the outcomes of these mechanisms, how would that help manage tensions moving forward?
Thanks, Ivan, and thanks, Henrik, for the question. You know, China is a party of UNCLOS, and even though that is denying the ruling of the 2016 ruling, but you know, the arbitral tribunal ruled that it has jurisdiction over the case, and the decision is legally binding. And so I think for China's, you know, refusing to comply with the rulings, you know, will lead to a serious reputational damage on international communities. And if you look at, you know, what countries, you know, support or oppose the rulings, you see like a long list of countries who positively acknowledge the ruling, and several countries, including the United States, Japan, Germany, Canada, Australia, United Kingdom, and New Zealand, they explicitly supported the ruling. So I think that, you know, by imposing pressure and reputation damage on China, I think that will encourage other countries like, you know, Vietnam or Indonesia or Malaysia to find similar case in the future.
Thank you, Vic. The next question goes to all three of you, but I'm going to try to combine these questions because I think they all speak about the same thing, which is going back to our earlier discussion, the sort of external dimension of the COC. So the first part is sort of the effects of external events shaping the internal dimensions in Southeast Asia. To what extent has a new bloc like AUKUS affect the COC negotiations, if at all? And then the second part, with all of the emerging uncertainty surrounding the South China Sea, what could be, or is there a strategic approach of ASEAN towards India? So one is sort of from outside looking in, and the other one sort of from the inside looking out. Let me start with Colin. Colin?
Thanks, Evan, and appreciate the questions. Now, you know, I think so far we have yet be able to observe any direct link, you know, between the announcement of AUKUS last September and the ongoing process for the COC. But to postulate the likely effect of it is that, you know, AUKUS might potentially make China more worried about, you know, not having a COC in the end. I think we have seen some of these external developments actually helping to catalyze the process in a sense, because I think in a way China wanted to use a COC as a way to regain the initiative when it comes to the narrative over the South China Sea, to show that, you know, Asian countries or littoral countries themselves are able to manage it, and there is no need for any extra regional, you know, sort of meddling in that process. So, you know, it might be the case that AUKUS could potentially help to facilitate the discussion more than, you know, helping to, you know, destroy the process at all, because China and at least some of the ASEAN member states would not want to see the process destroyed in the first place for their own specific reasons. So when it comes to India, I think this is the one question I thought was very interesting, and I'm glad that it was being asked. The strategic approach of ASEAN towards India, and given the fact that India has, in fact, since the 1990s, been seen as a potential counterweight to China, and, you know, at least seen as, you know, a viable, you know, power being able to, you know, countervail against, you know, potential hegemon in the area, right? So I think India does continue to play that role, but I think it's important to note that, there are some limitations to what India can do in Southeast Asia, not least the South China Sea. We have seen, of course, India recently improving on its position in the South China Sea, in particular with the latest BrahMos sail to the Philippines, and that might potentially presage more of such sails in the future. So in other words, I don't see ASEAN countries looking upon India as anywhere different or anything different from the rest of the other extra-regional powers. But I think there is some sentiments that India ought to step up on its involvement in the regional dialogue, and not least, of course, with the South China Sea. Thank you.
Thank you. Aristio?
All right, so thank you. Just add a little bit about what Colin have said. I think I agree with most of Colin's points on the role of AUKUS. I think the role of AUKUS, I think, might have like the good things is that it will increase the China insecurity, and therefore China, I think it will push the China's interest to avoid the involvement of other external powers here in the region. So I think it pushed the interest of China to conclude a South China Sea Code of Conduct. I think to keep remain the Code of Conduct only between the ASEAN, the South China Sea dispute only solely between ASEAN and China. But I think some sort of like negative, in fact, I think, and of course with the Chinese insecurity, that there might be possibilities. I think I would agree with what the Malaysian's foreign minister said, that ASEAN respond to AUKUS. It also depends on how China respond to AUKUS, and how the AUKUS can provoke tensions in the South China Sea. But I think with that in mind, I think it's back to the first point. I think it will put China to negotiate it and really seriously negotiate the Code of Conduct to avoid the involvement of the extra regional powers here in the disputed area.
Thank you. Bich?
Yeah, thanks. So I think, it could be the case that AUKUS could act as a catalyst to, fast tracking the COC, like Colin mentioned. But in my opinion, it also could pose a challenge, like it showed the divided opinions among ASEAN members. So, for example, I mentioned earlier that Indonesia and Malaysia was quite concerned about AUKUS, but Singapore strongly supported it. So it could divide ASEAN further. And if the Code of Conduct, it is concluded on based on consensus, then any country have the veto power to block the conclusion. So that's my thought on the AUKUS question. And for India, I don't think it's helpful to ask about ASEAN approach as a group to India, because India's relations with different South Asian countries, varies. So I could talk about, Vietnam's relation with India, for example. So, India has, experience operating Russian military equipment. So it has helped Vietnam to train its navy to operate the Kilo-class submarines that Vietnam purchased from Russia in 2009. So that's one of the examples that how India could play in the South China Sea and South Asia. And the reason why India wants to help Vietnam, because it's concerned about China action in the South China Sea could have some implication to China's in Indian Ocean.
Thank you, Bich. I think this next question is also to Bich, because I think this is a good, important question. This is from Ian Xiao. Bich, to what extent would exerting reputational cost on China deter it from its actions in the South China Sea?
Okay, thanks. Oh, okay. Thanks, Ivan, and thank you for the question, Ian. So, so for now, the reputational cost is just mostly on the narrative, but in the future, I think that if more and more countries, together criticize China, and it could lead to something more concrete. For example, they may, partner with each other to do something to reduce China's economic influence, for example, then it will impose more cost on China to apply with the international laws.
Thank you, Vic.
Thank you.
This question is for all three of you from Eric Javier. What are the prospects for a COC between ASEAN members? Because apart from the disputes between a few of the Southeast Asian states with China, ASEAN claimants are also in dispute with one another in terms of their maritime boundaries. Would it be better then to conclude a mechanism between ASEAN members first, so as to be able to show more united ASEAN when engaging with China? Let me start with Colin. Colin?
Thank you, Evan, and thanks, Eric, for the question. I would say that, not the COC per se that should first apply to ASEAN member states. I think more importantly, if we need to be more ambitious about it, is for the ASEAN member states with disputed claims in the South China Sea to resolve their overlapping EEZ boundary issues first. I think with that, I'm referring to, for example, between Indonesia and Vietnam in that regard, because this has been a lingering issue over the many years. There have been very polite discussions about the need to conclude EEZ boundary dispute, but this hasn't been forthcoming yet. Even after a number of incidents that involve Vietnamese fishermen and law enforcement agencies and with the Indonesian in the Natuna areas. And of course, the one between Vietnam and Malaysia concerning IUU fishing. I think at the operational level, resolving these issues together with addressing the overlapping EEZ boundary will be a good way to showcase the intra-ASEAN unity and use it as a leverage on the table when it comes to the COC discussion with China. So I think in a way, what I'm trying to stress here with urgency is for ASEAN countries themselves to address their own intramural problems first before we even go to the table. Otherwise, we are going to be saddled with the 10 versus 1 format of discussion and not the ideal or envisioned ASEAN united ASEAN position against China at the table itself. Thank you.
Thank you, Colin. Aristia?
All right, thank you very much. I think it's a really interesting question on whether or should not ASEAN internally create a code of conduct. I think that is also possible, and I think that is an interesting thing to have, because as I addressed in my articles, there's a point that UNCLOS also underscore or highlights that there might be a possibilities of creating a professional measure upon maritime boundaries delimitations settlement. So I think under the Article 84 and 73, I think it deals with kind of professional measure on what can be done and what should be done, and how to deal with the, for example, sharing fisheries resource or other resource management. So I think that is kind of possible. For example, and some of ASEAN states, I think, already had some kind of measure. For example, between Indonesia and Malaysia, we do have an agreement in unresolved maritime boundaries. What should the Indonesian law enforcement do, and what are the limitations of law enforcement? For example, if it is a traditional fishing fisherman below a certain gross tonnage, and then they should not do law enforcement, those kind of things. So I think there is already a practice there, and it's certainly possible for ASEAN to have internally a code of conduct if we see from that matter. However, I think it's impossible. It's possible, but I think it's not really address the giants of problems here, which is China, because a lot of provocations that happen in the South China Sea, it's mostly done by China Coast Guard and China's Navy. So I think even though I think we ASEAN internally have a code of conduct that regulates measures in the disputed maritime boundaries or in the unresolved maritime boundaries, it is possible, I think, to have that. But I think the main problems, the provocations, the it's going to be still there. But I think I agree with Collins. It might have to become a showcase that ASEAN can agree upon something if it's not involving China. And it's also good to tackle issues such as like eye fishings between the ASEAN countries or ASEAN member states. So I think it's possible, certainly, and it's a good things to do before we do have a more code of conduct with China.
Thank you, Aristeo. Bich?
Yes, so thanks for the question, Eric. So when you talk about, a code of conduct between ASEAN members, I tend to agree with Colin about, like bilateral negotiation, between the pairs, for example, Vietnam, Indonesia, and Vietnam, Malaysia, instead of ASEAN as a group, because, the more parties there are, the longer the process and the more difficult for them to come to an agreement. So that's my first point. And the second is, there's a kind of risk there if they the pairs of the parties agree on anything, but still at the same time there is still China's claim there that is illegal. So if they agreed on the other parties, then it could lead to some negative implication regarding to China claims. So they wouldn't want to do that. And then another issue that challenge is that for example, it's about domestic laws of the parties. So for example, Indonesian law acknowledged the median line in boundary delimitations, but to my knowledge, Malaysian law and the Vietnamese law don't acknowledge that. So in order for Vietnam and Malaysia to come to any agreement on boundary delimitation, they have to do something with their domestic law first.
Thank you, Vic. And I think because Indonesia was mentioned a couple of times, I think this question to all three speakers as well. I'm paraphrasing a little bit from the question by Ha-An Nguyen Hui. What are your expectations for the COC process under Indonesia's chairmanship of ASEAN in 2023? Will it change compared to the current one, or what do you expect out of that chairmanship next year when it comes to the COC? Let me start with Bich again, since you mentioned Indonesia last. Bich.
Okay, thanks for the question. So I think that with Indonesia's chairmanship of ASEAN, then it could be like maybe for the chairman's statement, maybe it's more forward, more explicit, talking about the South China Sea disputes and the code of conduct. But the code of conduct negotiation itself include China and other association countries as well. So I don't think that, as the chair, Indonesia can change much about that.
Thank you. Aristeo?
Yeah, I think I would agree that there would be like a dramatic change just because of Indonesia, the chairman of ASEAN. I'm surely that it's because of the Indonesian interest to have the code of conduct as well, that Indonesia might push for like a more negotiations process or creating a strong statements in regards of the COC. But I don't think we can expect there's like a huge or dramatic change or like a promise that the code of conduct will going to be settled within the Indonesia chairmanships. But I'm sure that because of it's in Indonesian interest, and also we have like more flexible relationships, I think Indonesia will push more meetings. I think during the pandemic as well, Indonesia was like intentionally hosted negotiations, right? But then it canceled due to the pandemic. But so I think we can see more effort from Indonesia leaderships to create more negotiations process. But I don't think that is necessary that there will be like a jump or like a dramatic conclusions or in the process of the COC negotiations.
Thank you. Colin?
Yes, to build on the very good points that Bich and Aristeo had mentioned, I don't want to belabor on them again, but just to build on them, to highlight that I don't think it really boils down to any one particular ASEAN country who is helming the chairmanship of ASEAN itself. And of course, the different style of chairmanship could lead to different initiatives. But when it comes to the code itself, I don't see or foresee any particular change in the progress itself. Very likely, it will be things that are beyond Indonesia's control. I think one of which being the ongoing global economic problems, inflationary pressure, and the uncertainties concerning pandemic recovery are likely to draw attention of some of the ASEAN member states away from the Code of Conduct negotiation. And to some of them, at least, this process is more of a distraction than anything else. So this is something that I don't think Indonesia is in much of a control over. And I think that also applies equally to any of the ASEAN member states. But that being said, given the ongoing return to in-person discussion, I think at the very least, next year, we might be expecting, some progress when it comes to the actual in-person discussion on the COC, and maybe that will be more helpful in promoting some process forward thereafter. Yeah, thank you.
Thank you all. Since we're about to run out of time, let me ask the final question. And as this is your last word, if you can answer this question all in 1 minute each. I think what's interesting about the debate today is that, we have taken the COC process all for granted. It's there, let's keep doing it. We don't know when it's going to end, but let's keep doing it anyway. I think what's interesting about the debate is that it's not as simple as that, right? And we've seen debates about different arguments about why we should keep it, about why we should not keep it. And what I think we want to know more, and I hope this will also come out in your essays, but my last questions for all three of you is simply, how do we know a good COC when we see one? How would you define a substantially good or a substantially bad COC? So bad that we have to walk away, or so good that we have to keep it? How would you define a good or bad COC? 1 minute each, if possible. Let me start with Bich. Bich?
Yeah, thanks, Stephen, for the question. Let me see. What is the first part of your question again?
Sorry, I guess the simple question is, how do we know a good or bad COC when we see one? How would you define what's good or bad about the COC?
Oh, I see. Okay. But before that, I would like to address that I think the purpose of today's discussions, also the essay series, is not to say that where the Southeast Asian claimant will or will not do something, because I understand that they may not have the reason to keep doing what they do, but the purpose is to say that whether they should. So that's why my arguments say that even though they may want to keep doing, the following the process, but I say that they should walk away. But back to your question, I think a good COC should clearly state the scope that all parties agree upon, and then have a clear list of don't and do. And then also there is some mechanisms to address the violations of the conduct.
Thank you, Bich. Aristio?
Thank you very much. I think two things on whether or not we know that the Code of Conduct is good or not. I think the first one and the most important is in compliance with international law. As I said earlier, all the provisions, all the scope of regulation should be based on the United Nations Conventions on the Law of the Sea, and also should not agree upon something that is illegal under international law, because there will be the Code of Conduct, I think, will be the basis of a further possible collaborations, and anything. So it should be based on the rule of international law. And the second, I think it's very important for all the parties to comply to the agreed Code of Conduct. So there's no point to have like a very good Code of Conduct, even though it's not legally binding, and no one observed, no one comply with the Code of Conduct. So I think it's not a zero-sum game. I know that there might be a negotiations, there might be a take and give between all the parties, but I think as long as it's comply with international law, and all parties intend to comply with it in order to prevent security issues, and also in the regions, I think it's two of the most important thing.
Thank you, Aristio. Colin, you have the last word.
Thank you, Evan. Of course, the code is bad if the first violation takes place not long after it's been promulgated, and by that it will be too late, of course. That being said, I will perhaps offer that for us to come to understand that there is a potentially good COC in the making, is for us to start to, on the broader textural basis, change the direction of the discussion over the single draft negotiating text. If you look at the existing text, at least dated from the originals back in 2018, look at all the proposals, overwhelmingly are regarding practical security cooperation, things like search and rescue, and environmental protection and all that, and very minimally on things like CBMs and whatnot. So I will say, I'll offer that we will know that there is a good COC in our way if we start to see all 11 parties started to put more serious attention and focus on looking at the CBM process itself. Then we will see that we can at least postulate that they are more serious in having a working COC than one that is simply just pro forma more than anything else. Thank you so much, Evan.
Thank you so much, Colin. Let me first say thank you again to all three wonderful speakers who I think addressed the questions very eloquently. We've had a very good set of questions and answers, and I think I certainly have learned a lot from the discussion over the past 90 minutes or so. I'll welcome you again to our next Counterpoint Southeast Asia episode in about a month and a half from now. You'll hear more details from us, and the essays from Bich, Aristio, and Colin will soon be up, hopefully next month. And then you can see how I think we're trying very much in our best effort to enrich the debate over key strategic questions facing Southeast Asia. Thank you again, and I hope to see you again in the next episode of Counterpoint Southeast Asia. Have a good day and stay safe. Bye-bye.
Thank you so much.
Thank you very much, everyone.